distinguished delegates, dear colleagues and friends, it's a great pleasure to welcome you to this roundtable, which focuses on the role of the special procedures in early warning and drawing attention to emerging issues. As participants well know, the special procedures of the Human Rights Council have often been called the eyes and ears of the international human rights machinery. Towards the end of my speech, when you see how active they are, I'm going to give them some limbs as well. But right now, eyes and ears of the international human rights machinery. We have 55 mandate holders who are independent experts appointed to deal with thematic or country issues. And they address a total of 39 mandates which cover all human rights: civil, cultural, economic, political, and social. And their mandates, provided by the Human Rights Council, enable them to focus on specific situations and to make recommendations to governments and other stakeholders to address problems that the mandate holders identify. These mandates are not prescribed by treaties. They are based on the Universal Declaration of Human Rights, and mandate holders can deal with situations wherever they occur in the world. I welcome the increasing joint initiatives by the special procedures, including joint reporting on cross-cutting issues and situations. By virtue of their mandates, the special procedures have a number of tools, and let me list some of them. They can receive information from virtually all credible sources and interact with a variety of partners, including governments, United Nations entities, civil society, victims, and their families. 2, they can conduct fact-finding missions, which allow them to assess independently the human rights situations in countries. 3, they send communications to governments to clarify allegations of human rights violations. They issue public statements about questions of concern. And they conduct research and studies and organize expert seminars and consultations to further develop human rights law. The special procedures report publicly on their work to the Council and or the General Assembly, and they engage with governments in a constructive dialogue on their recommendations on how to best protect and promote human rights. As High Commissioner, with the mandate provided by the General Assembly to bring critical human rights issues to the attention of the international community, I have an important partnership with the special procedures. They are not only, as I said, the eyes and ears, but also oftentimes the independent voice of human rights. Human rights issues that special procedures focus on should attract the attention of the entire United Nations system. In this connection, there is a need for increased attention to human rights issues in actual or impending crises and early warning processes. It is now widely recognized that human rights issues are critical at all stages of conflict. Violations are often a root cause of conflict, and human rights are always an indispensable element in achieving peace and reconciliation.
So there are examples where warnings have been given, but unhappily the examples are that despite the warning, action has been delayed. So we should be looking at, from the time of the warning to the actual moment of action, what are the mechanics and what are the, how does that warning then rings the bell so that it's heard on the other side.
In fact, I believe we could explore the idea, which I'm now road testing within my mandate, of systematically tracking the responses from states in order to make visible which are the states which respond, which are the states which do not cooperate, and which are the states which provide answers which are constructive and provide the information sought, rather than responses which are just pro forma. I believe that by making more visible the responses which the states provide us with, not only in the annual report on the communications which we prepare for the Human Rights Council, we could greatly enhance the effectiveness of this system.
And so I would just like to recommend, and I do this not on behalf of the committee, but in my personal capacity, I'd like to recommend that there can and should be more regularized interaction between the special procedures and the Security Council. It seems to me there are two models that already could introduce an evaluative mechanism into this picture. One model is that of the Special Advisor on Genocide Prevention. The other would be the creation, doesn't exist, it's a model, the creation of a regularized reporting and participation process by the High Commissioner for Human Rights, or if a new post, which we hope would be created, a post of Assistant Secretary General for Human Rights in New York, could participate on her behalf. The Special Advisor on Genocide Prevention, as you know, is not mandated to gather first-hand information, but to collect that from others in order to assess and reach judgments about the prevention of genocide. A network of UN human rights special procedures could be created to facilitate the routine sharing of key information and identification of risk factors that may lead to genocide. It doesn't exist at present, but it
I
could
think
be.
my premise, first of all, is to note that special rapporteurs, special procedures have a certain humble value added as early warning, because they're already linked with human rights issues, humanitarian issues, and emergency issues by the very nature of their work. And in that perspective, we should note that they are pro bono people who are drawn usually from the field, from an environment that is in touch. Secondly, they are naturally information, data analysts and advocates at the same time, so they have a certain communication capacity. Thirdly, they are in a natural position to activate because they're linked with the Human Rights Council and beyond, and we'll see the potential for other links in due course as part of the global mobilization.